out some more questions. I'm going to do 16, 17, 24, and 27 in this round. Okay? So, with 16, we've got Fred Mabonglo, and one of the issues is who drafted a particular provision of the contract. Now, this is a really technically difficult question. And I should tell you, on my last exam, the one at Penn State, I bumped everybody up by 15 points. So if this helps you feel better, I hope it does. Anyway, so Fred was planning on calling the other lawyer who was involved in the transaction as a witness, and the witness was going to testify that he drafted the provision in dispute. 2 days before the trial, the lawyer had a massive heart attack and passed away, so Fred's the only one who has this knowledge about who drafted the contract provision. So which of the following should Fred do? A is Fred must withdraw as counsel in this case due to the conflict now that Fred wants to be a witness. Fred can draft. B is Fred can draft and act as trial counsel as long as he has the informed written consent of his client. C is because Fred's testimony will be favorable to his client, he and his firm can proceed. And D is Fred's firm can act as trial counsel even though Fred will be a witness. Because the issue here, and we're getting to this as we talk about duties to courts, is Fred really creating a conflict with his client? He's actually clearing up something for his client. So look in the fact situation when you have it and see, what am I doing? Am I serving the interests of my client? If I'm not serving the interests of my client, then this is probably not something I should be doing, but here I would be. Now, because courts don't want to see the lawyer jump into the witness box and, who would question Fred, we need to have a situation in which someone is acting as an attorney. And if Fred's going to be a witness, he shouldn't be an attorney too. So we look at Rule 3.7, and it says basically that the client could suffer some substantial hardship if Fred is pulled out of the case now. We know Fred's testimony is going to be favorable to the client, so we don't really have a conflict. But if you look at 3.7b and the comment 6 to that rule, A is wrong because the firm doesn't have to withdraw. B is going to be wrong because 3.7 has no provision for the client to waive an advocate-witness conflict. And C is too general, really. There are times when he would have to withdraw, even if his testimony would be favorable to the client. Here we have a situation where we need to ensure that his testimony gets in, but that Fred isn't also acting as the counsel in the case at the time, because that becomes too confusing in our justice system. So we're going to move in that direction as we talk more about judges and conflicts, and hopefully those rules will make sense to you as we get there. We haven't covered that yet. 17. So Bob Dylan, he's an attorney. He's assisting an elderly client in the preparation of his client's estate plan. And his client wants to leave some real estate for the exclusive use of Caucasian heterosexual men and boys. Bob is prepared to give his client advice about the legality and the enforceability of such a provision, but what statement most accurately describes Bob's options under the rules? So here, remember the first week of class, when the correct answer is C. Bob can talk to his client about the morality of that and whether or not he agrees with it, but he's not required to. Remember, when we were first talking the first weeks about what lawyers can do, we mentioned that lawyers can be moral advisors too. That some people actually think lawyers should be giving ethical, moral, religious, healthy life kind of advice. And so if that's what Bob wants to do, that's perfectly okay. That's why C is the correct answer. So Bob is allowed to give out that kind of advice. He's not required to, but some clients might appreciate it. Would this client appreciate it? I doubt this client would appreciate it if Bob disagreed with his, idea to leave this to Caucasian heterosexual men and boys. But it's, you might think that you have a special relationship and you could have an influence on your client before he dies and could maybe change some of his attitudes that you think are antiquated. Okay, so Miranda Dewey on 24 represents Billy Crystalloyd as a defendant in an armed robbery case. So Miranda's been asked by Billy's father, Leo, to draft his will to disinherit Billy. So Miranda's got the separate case, and then Leo says, hey, you know, that Miranda woman, she's been pretty good as an attorney. I should hire her to redraft my will, because I'm really sick of Billy. He's, you know, been in this armed robbery case, and he's always getting in trouble. I really don't want to reward him for his poor behavior. So this kind of stuff's perfectly legal in the state, as we talked about. Leo doesn't want advice. He just wants her to change a line of the will. He's already decided. He doesn't want to hear anything else about it. He just wants Miranda to just write it up. Now, this is a common MPRE question. I understand it's really tricky, so be on the lookout for it. There have been a number of ABA decisions that say merely being a scribe, just writing something up, just drafting that up, just, you know, just finish that one line for me, doesn't necessarily create a conflict of interest. So something to tuck away, because I've seen this in a lot of MPRE prep books. So that's why D is the correct answer. While her representation of Leo is ultimately going to be adverse to the economic interests of Billy, mere economic adversity doesn't do it. And she actually wouldn't be disclosing confidences in order to put herself into this kind of situation and do work for both of them. Leo's saying, I just want you to change these words in the will. Now, if they had a more extensive relationship that involved client counseling and sharing of confidences, that might be true. But just merely because you have some information, no matter how slimy it might make you feel about one of your clients that you got from another client, doesn't mean that you have a conflict of interest. So, you know, here's another example of this. You can have two businesses come to you and say, we've already hashed out the details, we just want you to draw it up for us. And you could do it for them. Now, you may think, and I would agree with you, that your duty is really to tell them you might need further advice down the road. It's possible that you could need, you could have a conflict in your interests. It's possible that when I start drafting this for you, there will be things that are not fair to one side. And if you don't have legal representation and I'm just acting as a scribe, you're really tying my hands. So just look for those kinds of situations on the MPRE 2 where you're being asked to be a mere scribe. And that we're using a different version of the textbook.